May 18, 2012. This is Justice Done Dirt Cheap, heading down to the courthouse for a scheduled hearing. I was told they're just going to be adjourning the matter, and I'm hoping that's all that's going to occur. It was originally scheduled to be a trial of a bylaw matter, but today it turns out it's supposed to be just an adjournment of the matter. Now, why I need to go in for an adjournment of a matter is interesting to me. Seems odd. I've been at other court hearings where matters have been adjourned and there's been no need whatsoever for me to appear. So today seems to be something different. This is the same court file which I've filed a charter challenge challenging the validity of the bylaw which the city of Fredericton is attempting to have me fined under. So I attempted to get a written confirmation that the matter was only being adjourned today, because it's been weeks now that I was told the matter would be adjourned. So instead of preparing for a trial, I'm only prepared for an adjournment, which means no real preparation. So I received an email this morning from Catherine Wilson, who's in charge of court services, the provincial court section. She confirmed that she's aware because the court staff had informed her that it was the intention of the court, and I have been informed orally that the matter would be adjourned today. Now, I'm hoping everything goes well. I am happy I wrote that email though, getting confirmation of what time the hearing was at, because the hearing was originally scheduled for 2:30 p.m. and they've changed it to 1 p.m. If I hadn't sent that email, I would have missed it. So it's another lesson to get everything you can in writing so that we can avoid mistakes and human error, especially in communication. When people are just telling information from one person to another, it's easy to mistake the who, why, where, and when. So get everything in writing. Lesson learned. Alright, so I'll give you a video afterwards to tell you how everything went. It's exciting because in the same file I am, like I said, I'm challenging the City of Fredericton bylaw section 15, or section, what is it, T4 subsection 15. That's the name of the bylaw, which is riding on the sidewalk with a bicycle or motorcycle. The mere fact of riding on the sidewalk can get you a $50 to $500 fine, and at this time the City of Fredericton Police Force used this bylaw to arrest people who they otherwise would not have probable cause to arrest. So this bylaw, as it stands, is in violation of our charter protected rights. I'm interested in enforcing my charter protected rights, It's important to understand these rights existed before the Charter, but the Charter gives a legally actionable method to enforce our Charter rights. It acts as a vehicle by which our rights can be enforced, protected, and exercised with some authority. So, off I'm going to the hearing, which I've been told is an adjournment of the matter. I'm looking forward to see how it turns out today. Oh yeah, as a side note, the first time I appeared regarding this bylaw matter, I actually made a special appearance, which is a unique legal concept where at the outset of a matter, someone can make a special appearance rather than a general appearance where they appear before the court, but in a special capacity only to argue whether the court has jurisdiction or not to actually hear the matter. Now I did that, so the first hearing I was at, I told the court that was my intentions, and I gave my explanation of why I thought the court did not have jurisdiction. That was before Judge Dixon. That's Justice Julian Dixon. He asked the solicitor representing the city of Fredericton what he thought of that. And what was interesting is the solicitor for the city of Fredericton, George E. Kalinowski, basically said, and I'm paraphrasing here, well, let Mr. Murray plead and then we'll deal with the jurisdiction matter afterwards. Now, because I knew the subject quite well, I found out that to plead means one loses. The effect would be one would lose their ability to claim special appearance to challenge jurisdiction. Because as soon as one pleads, it's accepted that they're attorning to the jurisdiction of the court, which means they're agreeing to give jurisdiction to the court to hear the matter. Now, the special appearance capacity allows one to argue why the court does not have subject matter jurisdiction, which means the judge does not have jurisdiction to hear the matter before him or jurisdiction over the individual standing before them. So at that first hearing, the court offered for me to file a brief and a formal motion on the matter. He said I didn't even have to file a formal motion. If I chose to, I could just write a letter stating my legal position. So I did that. Filed a substantial brief, which I can place in the description area of this video, so you can go read that brief. It's pretty interesting because it clearly shows that the court does not have subject jurisdiction in my matter. What ended up happening was the judge, after considering the matter, decided that he was of the belief he still had jurisdiction. I did not agree with that decision, so I filed an application for judicial review. It's Form 16D of the Forms of Court. So I'm having a higher court review the matter of the jurisdiction issue. In the meantime, the new judge who's taken over, who is Justice Richard, has decided that despite me filing application for judicial review, there'd be no need to have an adjournment of the matter. So they're going ahead with the trial, and that's when they scheduled the last hearing. They had intended to go forward with the trial. I had objected because I was not prepared to go forward with the trial, because the matter of subject matter jurisdiction is yet to be decided conclusively. The judge ignored that and decided to go ahead with the trial anyway, under my protest and objections. I don't agree with that. She refused to adjourn the matter so I could actually properly cross-examine the police officer who took the stand that day. Then she adjourned the matter so there could be another day set for the hearing of the argument of whether I'm guilty of violating City of Fredericton Bylaw T4 Section 15. So that matter was scheduled to be heard today, and then I found out afterwards that they decided to adjourn the matter. I don't believe they gave me a reason. They just said they were adjourning the matter for a month and gave me new dates. So I went ahead based on that information. And it's a good thing I sent that letter today confirming the matter was indeed adjourned and what time it was scheduled to be heard. Now what's interesting is the matter was changed from 2:30 to 1 o'clock. Without that letter, I wouldn't have known. So I'm happy I sent it. Lesson learned, again, get everything in writing. So that's a real quick recap to date. I'll try to put the links to the actual documents that I filed in the description so you can read along at the information I provide to the court. It's pretty interesting because most people do not question the jurisdiction of a court to hear the matter. What's really interesting is that the provincial court judges are considered inferior court judges as opposed to superior court judges, which would be Court of Queen's Bench judges. Court of Queen's Bench judges are assumed to have jurisdiction, original and complete jurisdiction in all matters, unless they can be shown otherwise. Now the opposite is true for provincial court judges, where nothing is considered to be in their jurisdiction until it is proven to be so. And that's quite the opposite, and that's what makes my legal position quite strong. When I can show that they do not have jurisdiction, and they can't show that they were granted jurisdiction in my matter, they can't hear it. Alright, so that's a recap to date in this provincial court matter regarding city bylaw infraction. Thank you for listening. This is Justice Done Dirt Cheap, May 18, 2012. Heading down to the courthouse. And what's interesting is with courts, you never know what's going to happen until it's happening. So, thanks for listening. Have a great day.